There is a matrimonial proceeding going on before a court, which relates to judicial separation of the parties or settlement of properties, dissolution of marriage, which is also the same thing as divorce. You hear terms like access, custody. So today, let us see how we can actually distinguish one from the other. First, let us look at what access really means. It means permission, liberty, ability to enter, to approach, or to pass to, or from a place, or to approach or communicate with a person or something. So when you go to a court, you are having judicial separation proceeding in court, or you are actually going through a divorce and you are discussing about the well-being of the child, who has control, who should take control, who should take decisions over the children. You always hear this word access. So when the court gives you access to the child, it means that the court is permitting you to have the ability to approach that child, to come near that child, ability to communicate with that child or the children of the marriage. Now, if the court looks at you and deems it fit that the only relief that it can grant you is access, it says volume. It means that you lack the capability to take decisions over that child's life. So if the court looks at you and pities you by granting you access into a child's life, meanwhile custody has been given to another, it means that that other person who has custody over that child has or stands in a better position in the view of that court. So on the other hand, when we talk about custody in the context of children, where there is a matrimonial proceeding going on in court, we're talking about that legal right and responsibility that the court vests in a person to take care of a child. It means especially where the parents are going through a divorce or a separation process. It could be physical custody, which means that the court will look at the person and say, okay, let the child or let the children of this marriage come and live with you. That is physical custody. Okay? It could also be what? Legal custody, which means the court says we vest in you all the duties, all the responsibilities, all the powers, all the rights to take decisions concerning the life of this child or these children. So for people like us who are in Nigeria, the legal framework regulating custody of children will also depend on the nature of the marriage or the type of marriage, which means if it is customary marriage, we also have rules, values that govern customary marriage and customary lifestyle. Okay, so if it is also an Islamic marriage, we have how it is what looked at. For the Muslims, what they see, they give custody of their children or the custody of the child to the mother. Customarily, custody is given to the man. But I want to bring it to your notice that in cases where the court is of the opinion that the man lacks the capacity to cater for the children or for that child, even if it is a customary marriage, the court will not give custody to them. And there are decided cases like that. Why? Because what the court is bothered about, what is paramount in the mind of the court, is what is in the best interest of that child. There is no sentiment about it. The court is looking at what will serve the best interest of this child or these children. their education, their shelter, their clothing, their feeding, their well-being generally. That is what the court is what's concerned about. There are also instances where there's a case where the woman formed the habit of, she will get married, then after a period of time she will seek for divorce, and all those child support she will collect them from the man. So this is what she has been doing, and by the next divorce proceeding she instituted in court, the court said, no, we are not giving you anything, because this thing is like a pattern for this woman. We can't even give you custody of these children. You can't take care of them. Or you are a woman, you are living in a house full of commotion. The court will not also give you custody of your children. That is why I said in one of my previous videos that the court will always look at the conduct of the parties, their circumstances in life. All of these things, your earnings, all of these things will weigh on the mind of the court when it wants to decide or determine custody matters before it. Why? What is best for the child is what is paramount in the mind of the court. Let us also look at a situation where grandparents can have custody of the children or of the child of that marriage. Basically, in Nigeria, we do not have a legal framework that will say, okay, well, grandparents can do what? Get custody of children. But where it is allowed, this is a kind of special custody. But customarily, we have instances where children are in the custody of their grandparents. They are in the custody of their grandparents, and in some cases, these grandparents are well and capable enough to take care of those children, either as a result of separation, as a result of death of the parents of the child, then they can, or discipline aspect, they can decide to take over the upbringing of the child. But there are challenges with leaving children in the hands of what? Grandparents. But before we go to the challenges, first, there is this notion that children who grow up with their grandparents turn out to be both better and wiser. But that will depend on who that grandparent or those grandparents are. If that grandparent is lazy, if that grandparent is reckless and irresponsible, it will also turn and be represented in the life of that child or those children. It can only be on a positive note, where the children will turn out to be smarter, wiser, where the grandparents or those grandparents are responsible and not reckless. Okay, but now looking or considering granting custody to grandparents in this dispensation, with technology everywhere and every child wants to have access to technology and the modern things that are in the society, it also depends on the status of life of what those grandparents. But one thing that we have been made to understand is that considering what is best for the child, sometimes it is not objective, it could be what? Subjective. I know that we had this conversation or this discussion in one of the papers I presented during my seminar presentations on the best interest of the child, when one of my lecturers said that this actually is a subjective application that the court will make. Why? Because the court will look at the circumstances and the peculiarity of each case. So depending on the social status of the parents involved, all of these will also weigh on the mind of the court. This is Xivial Law Essence. Here we give you premium legal tips to help you make informed decisions, live informed life, and discover the best version of yourself. We'll see you again. Bye.